Welcome to Legal Lines. This program is brought to you by the York County Bar Foundation. My name is Tom O'Shea. I am the host of the program. And my guest today is attorney Leanne Miller from CGA Law Firm. Welcome, Leanne.
Thank you, Tom.
And our topic today is prenuptial agreements, also sometimes referred to as antenuptial agreements. So Leanne, the first question I told you before we started is please define a prenuptial agreement.
Well, Tom, probably the best way to describe a prenuptial agreement is that it's a contract between two individuals that's entered into prior to marriage. And it basically addresses how their property will be distributed upon either death or divorce.
Okay. And I think that's an interesting thing because when representing a client who wants a prenuptial agreement, there are different reasons why people want them. And many people, it's for estate planning purposes, and other people, it's just the fear that they might have to go through a divorce someday and they want to know where things would be.
Right. So generally with a client, you'll sit down and you will ask them simple questions whether they want the prenuptial agreement to be valid upon death or divorce. Some people only choose the prenuptial agreement to describe what happens upon their death if they're married, or what happens, the prenuptial agreement will cover the divorce.
Okay, but the overwhelming majority of people have prenuptial agreements that would cover both instances.
That's correct.
Okay, but you can limit it just to one.
Right.
What
right.
would happen to my assets if I died while married? What would happen to my assets if I got divorced while married?
Right.
Okay.
Right.
And I think what's important for people to know before they enter into a prenuptial agreement, in real general terms, what happens if someone doesn't have a prenuptial agreement? Let's start first with the topic of separation and divorce. If there's a couple that is going through a separation and divorce and they do not have a prenuptial agreement, what's generally likely to happen?
Well, then Pennsylvania divorce law will apply to the division of assets. Pennsylvania is an equitable distribution state, and so a determination is made as to their marital property, and that is anything that's acquired during the marriage or any appreciation of separate property during the marriage. And the court will, our state law requires you to look at principles of equity and fairness in making or how you divide your assets. It doesn't mean that you're going to get a 50-50 split of those assets or that they're going to be split equally. So I think the bottom line is state law applies as to how you divide your assets in Pennsylvania's equitable distribution state.
And with equitable distribution, you're saying that that could mean that it's not equal, and maybe what your definition of equitable is different than your spouse's definition of equitable.
Absolutely.
Which might be completely different from a court's interpretation of equitable.
Right.
So that could also result in lots of legal fees arguing about what's equitable.
And that often happens.
Okay. And then also one of the things you pointed out is appreciation to an asset could be marital property. So if we were talking about, let's say, a house, one spouse owned the house before they were married. And let's say the house was worth $100,000 on the day they got married. They separate 10 years later and it's worth $150,000. The house might not be marital property under the divorce law, but under the divorce law, the $50,000 increase would be.
Correct. That's the appreciation of a non-marital asset.
But if you put in a prenuptial agreement,
you eliminate.
You could say that as long as the house is titled in one name, it remains that person's regardless of any appreciation.
Correct.
Okay.
Right.
One other thing that Pennsylvania law does with respect to a separation and divorce is deals with support issues, spousal support, alimony, and can that be dealt with in a prenuptial agreement?
Absolutely. And most people do include that in their prenuptial agreement. A majority of people will completely waive any right to spousal support or alimony in the prenuptial agreement. You also can include a limit on spousal support or alimony in the prenuptial agreement.
So you can limit it as to a dollar amount or or even a limit to duration.
Correct.
Okay. Now, that's generally what would happen without a prenuptial agreement. Let me switch about what happens in the event that one spouse dies and there's no prenuptial agreement.
If you die in the state of Pennsylvania without a will, you die what's called testacy. And there's, again, state law that determines what that surviving spouse would receive. If you die and you have children or living parents, your surviving spouse would receive the first $30,000 of your probate estate and then half of the remainder of your probate estate. Your children or your surviving parents would receive the other half.
Okay, so without a will, the state dictates where your assets go, and the spouse is certainly going to get a large share of your estate.
Yes.
Okay.
Yes.
And what about if you do have a will? So a married person, I would write a will and I say I leave everything to my children from my first marriage, for example. Would that control?
Actually,
if there was
again,
no prenuptial agreement.
if there was no prenuptial agreement, again, there's state law that allows you to take what's called the elective share. And you are allowed to elect against the will, and you receive about a third of the augmented estate of the deceased spouse.
What I see happen frequently is people with second marriages getting prenuptial agreements, especially if they have children from their first marriage.
Yes.
And that's a way to protect their children's inheritance, if you will.
Right.
Frequently they would be somebody who's widowed, and they have children from their first marriage, and what mom and dad acquired together, they can write, they can make certain that the new spouse doesn't acquire by virtue of the second marriage.
That's correct. The prenuptial agreement allows you to make sure that your surviving children from that first marriage would be able to receive some of your wealth
Okay,
or
so
your assets.
basically what you can do in a prenuptial agreement, as I understand it, is ask that the future spouse waive any interest in your estate, or at least limit his or her interest in your estate, so that you can be free to leave more to your children, or somebody else for that matter.
Correct. So in your prenuptial agreement, if you wanted to give that surviving spouse a percentage less than the elective share, you could certainly do that. Or if you wanted to completely leave everything to your children, that would be in the prenuptial agreement as well.
So with respect to the prenuptial agreement, with respect to divorce or separation, you can waive what the state law says that is marital property and have a contract as to what would happen with respect to your assets in the event of a divorce or separation.
Right.
That's basically what a prenuptial agreement
That's
does.
exactly what a prenuptial agreement
Okay,
does.
and with respect to death, it's basically saying the same thing. What the state says will happen to property upon death can be waived, and it will be distributed, by some other means, maybe by your will, or even by intestate laws if you didn't have a will, without the spouse automatically getting a share.
Yes, that's an excellent way to think about prenuptial
Now,
agreements.
with respect to the prenuptial agreements, it's not a matter of just waive everything or not waive everything. There's all kinds of space in between, correct?
That's the nice thing about a prenuptial agreement. You can really sit down and draft it or craft it to meet your needs. So if you wanted to leave some of your non-marital assets to your spouse, you can certainly incorporate that into the prenuptial agreement, or some people do want complete waiver of all their non-marital assets. So it's important to sit down with your attorney and really describe to them or give them a sense of what your intent is upon divorce or death with your spouse.
So there could be some negotiation process with respect to a prenuptial agreement.
Absolutely. Most people are encouraged, or I often encourage I think both parties should be represented by their own separate attorney when a prenuptial agreement is drafted. They don't need to be, but I think it's probably helpful that they sit down with an attorney and make it clear what their intent is with their assets.
If I were to ask who should get a prenuptial agreement, what would your answer be?
Probably everyone.
Everyone about to get married should have a prenuptial agreement.
If I had to, everyone, certainly everyone, it would be nice if everyone would. But I think if you are entering into a second marriage or a third marriage and you have children to a previous marriage or relationship, it's probably very important for you to sit down and consider drafting a premarital agreement. If you own a family business, that may be another reason to have a prenuptial agreement.
That's an important point, and I see that happen frequently when there's a family-owned business, especially if the business might appreciate during the marriage. A spouse of one of the family members might then have a marital interest in the business.
Right, and that can create all different types of issues.
And could result in having to sell a part of the interest or financing the interest to pay off the spouse in the event of either death or a divorce.
Right, and these are things that people don't realize or think about when they're entering into a marriage. They don't understand that can happen.
And with respect to a prenuptial agreement, can it be limited to just one asset, such as the family business?
Absolutely.
So you could say, well, I don't waive the whole definition of marital property and equitable distribution, but I do waive it with respect to my spouse's interest in the family business.
Absolutely.
And that could be done with other assets as well, the family farm, the house, or whatever.
Right.
Okay.
Right.
One of the things that I want you to point out is, can you deal with children in a prenuptial agreement? Can you deal with who would have custody of the children, or whether or not there would be a certain amount of child support to be paid?
No, you cannot.
All right. And what would, if somebody put that in a prenuptial agreement, and I have seen prenuptial agreements where people put that in, would it be valid?
You can put it in, but the court is not going to consider it to be a valid agreement.
The needs of the child at the time
are unique to the child, and you really can't contract that away. Okay. The same for child support.
Okay. And now what about with prenuptial agreements with respect to assets that people own prior to marriage, and there would be an increase in value? Can that be dealt with?
In the prenuptial agreement?
Yeah.
Absolutely.
Okay.
Yes.
Do you have, let me just check my notes here. I got a little lost. I apologize for that. I wanted to ask you about wills. Can you write, is it important to have a will if you have a prenuptial agreement? I guess it's important for everybody to have a will, so that's
again,
not a fair
I'd
question.
answer the same way I answered. Should everyone should have a prenuptial agreement? I think everyone should have a will.
We're going to talk a little bit more about wills in a minute. We're almost out of time here. My name is Tom O'Shea. This is Legal Lines. My guest is Leanne Miller, and we are talking about prenuptial agreements today. We'll be right back. Welcome back to Legal Lines. My name is Tom O'Shea. My guest today is attorney Leanne Miller from CGA Law Firm. Leanne handles family law cases, and we're talking about prenuptial agreements. So welcome back, Leanne.
Thank you, Tom.
And right before the break, I started to get into the issue of wills. Someone might have a prenuptial agreement. Is it necessary because they could write a will? And how do the two play against one another, the will versus the prenuptial agreement?
Well, Tom, with a prenuptial agreement, you can't unilaterally change it. So it needs to be an agreement between you and your spouse if you want to change it. The nice thing about a will is it's unique to you, so you always have the right to change your will. And so you could either leave more to her under that or just change some of the terms in the prenuptial agreement that deal with only you, not both of you.
So if you had a prenuptial agreement that limited what goes to a spouse in the event of death, either it's a complete waiver of your estate or a limited amount that would go to the spouse as a result of the estate, you can write a will that leaves the spouse far more than that.
That's right. That's
Okay.
a perfect example.
And you can then change your mind and unilaterally, without the consent of the spouse, say, well, I think I'm going to rewrite my will and leave you only what's in the prenup.
Correct.
Okay?
Correct.
On the other hand, if the prenup said the spouse is entitled to a certain amount in the event of death, and I got mad at my spouse and said, well, I'm going to change that, I'm going to write a will that gives my spouse less, then the prenup would control.
That's correct.
Okay? And it would only be if both parties would agree to change the prenup jointly that the spouse could get less.
Correct.
Which, what spouse is going to do that, right?
Right.
But that's the big distinction. The big distinction is that the will is something that is unilateral. You can do it by yourself.
Right.
And
Without
you can
the other
change it
spouses.
later on.
Right.
And the prenuptial agreement, it can be modified by both parties, but both have to agree to it.
Right.
Okay?
Right.
Which brings up another issue. People sign prenuptial agreements before they get married. I think
Right.
they have to
By
be,
definition.
they have to be prior to marriage to be valid. And do they, suppose two people sign a prenuptial agreement and then they decide not to get married. Does the contract mean anything?
No, the contract is void then.
So it only becomes effective if they get married.
Right. And that's written right in the prenuptial agreement, made clear to the parties that it's executed in anticipation of that marriage.
Okay. Now, I think one of the issues you touched on at the beginning, and I want to get further into this, is that for a prenuptial agreement to be valid, there has to be a disclosure of assets. Can you explain what that means?
Well, and I think the legal terminology would be a fair and full disclosure of your assets. It means that basically the spouse needs to know what you have. Okay, they need to know what assets you have and approximately what their value is. Does it mean you have to go out and get appraisals or get some type of valuation done? No. You have that opportunity. You certainly have that right. But you just need to know what your spouse has and what it's worth.
Okay, so in other words, if I was to be putting a prenup together and a client said, well, it's none of my intended's business what I own, I couldn't draft a valid prenuptial agreement.
No.
Okay, so what happens if somebody signs a prenup but there's no disclosure of assets?
It would not be a valid prenuptial agreement.
It could be attacked later on as being not valid.
Absolutely.
And generally, to prove that there was a disclosure of assets, what do attorneys do when they draft these documents?
Most attorneys, when they draft a prenuptial agreement, will have a list of assets. So generally it's done through an exhibit where, wife will disclose all of her assets. She'll have a list of those assets and their values. Husband will have an exhibit of a list of his assets, their values.
So basically the prenuptial agreement might have Exhibit A and Exhibit B, a future husband's assets, future wife's assets. How specific does it have to be?
In terms of...
No, do you have to have the exact value of everything?
Oh, no.
Approximate values?
No. I mean, approximate values is okay. I mean, you don't need it down to the penny, but you certainly don't want to underestimate it, but you want to be fairly close to what the value is.
So I believe the purpose of the law, correct me if I'm wrong, is if somebody knew that their spouse had several $1,000,000, maybe they wouldn't negotiate the same deal as if the spouse had a few $1,000s.
Right.
Okay?
Right.
And I think you said that it's not necessary to get items appraised. So if you said, well, there's a house and I think it's worth $200,000, for example, it's not going to be held against you if later on the house was proven to be worth $230,000.
Right. The other spouse would have a right to have an appraisal if he or she wanted to, but they don't have to.
Okay, and the same would apply to like assets that are hard to value, I would assume, such as like a business interest. I mean, I might be part of a family business, but I don't know what it's worth. But if I disclose that I have an interest and say to my intended spouse, you can have, you can hire an expert to figure out what it's worth, but it's there.
Right.
That would be sufficient disclosure.
Right.
Okay. Okay. And while we're talking about the validity of a prenuptial agreement, every once in a while, somebody gets a case where there is a prenuptial agreement and somebody challenges the validity of it. And how can they be challenged?
Normally, the only way to challenge the validity of a prenuptial agreement that's under Pennsylvania law is if it was executed or signed under duress, then it could be challenged.
What about fraud?
Or fraud.
Okay.
Yes, fraud and duress.
Fraud would be misrepresenting the document.
Correct.
Oh.
A majority of the fraud cases would be the valuation of an asset.
Okay, so in other words,
incorrect.
if there wasn't full disclosure, you said, this is my full disclosure, and later on we found out, oh, you also had a Swiss bank account that you didn't disclose, that would be a fraud.
Right.
And that would be a reason to attack the validity of the prenuptial agreement.
Perfect example, Tom.
Okay. What would be an example of duress?
Well, in terms of duress, most people think that on the eve of a marriage, someone might say or the eve of a wedding, may say you need to sign this prenuptial agreement or I'm not going to go through with the marriage. Pennsylvania courts have said that really isn't duress.
So duress would have to be something extremely
more significant than
significant, like
Yeah.
somebody threatening somebody with violence if they don't sign it or something.
Right,
like that.
perhaps a weapon involved or something like that.
That would be extreme.
Right.
But so duress seems like a very hard way to challenge a prenuptial agreement.
Right. Right.
Now, and you said that's the only two ways to challenge it in Pennsylvania. Okay.
Some people may think that you could challenge it on fairness, such that you had one spouse that is quite wealthy, another spouse that is not, and the prenuptial agreement gives everything to the wealthy spouse, or the wealthy spouse keeps everything. So fairness may be an issue. Under Pennsylvania law, fairness is not considered a valid reason to challenge a prenuptial agreement. That is not true in other states.
In some states, they'll look at a prenuptial agreement and say, well, this is so unfair that we are going to invalidate it. The court is going to invalidate it.
That's correct.
But that's not the case in Pennsylvania.
That's not the case in Pennsylvania.
So Pennsylvania takes the approach that if two consenting adults agree to something that might not be fair, it's a contract. Just
That's
like
right.
if I signed a contract to pay somebody twice as much as the house is worth, I'm still bound by that contract.
Right.
Okay, and that would be the same on the prenuptial agreements. One of the things that we find when people have prenuptial agreements is that they ignore them after they're signed. Can you explain how that is not a good idea?
Generally, what we see happen is someone changes how something is titled. So, for example, if a spouse entered into the marriage and had his own residence, and the deed was in his name alone, some point during the marriage, that deed was changed, and now wife is added to the deed. Okay, that asset's no longer deeded in just husband's name, and so it's joint property now.
So, in other words, if I had a prenuptial agreement that said this is my house. It's listed as my non-disclosed asset, and I then, a couple years later, say to my spouse, let's put it in both names. Even though the prenuptial agreement says that she waived all interest in that house, my act of putting it in both names at a later date makes it joint.
Correct.
Okay? The same would apply to other types of assets. Bank
Right.
accounts.
Right. Retirement accounts, mutual funds.
And sometimes people do that thinking they're doing the right thing, and then later on, believing they're protected by their prenuptial agreement. Unfortunately, they go through a divorce, and they find out that the prenuptial agreement did not protect them as well as thought.
Right. And it really is unfortunate because sometimes it's very lopsided. So one spouse may change how things are titled and the other one may not. And so suddenly you're in a very unfair situation.
Okay, I can see that happening not only with respect to a divorce or separation, but that could also happen if one spouse dies.
Right.
Okay, take the same example with the house. I agree that somewhere after the prenuptial agreement that I'm going to put the house in joint names. I have children from my first marriage, and now my will says my children get everything, but because I put the deed in both names, the deed doesn't, my will doesn't control on the house, the deed controls, and my spouse gets the house.
Right. And your children would be.
And the children would get nothing.
Right.
And I think that's an important point for people to know with respect to their estate planning, especially if there are children, because both spouses may have children. In a second marriage, both spouses may have children from prior marriages.
Right.
And if what I tell people is if you don't plan this right, the children from the second spouse to die could get everything.
Right.
And the children from the first spouse to die might not get anything.
Right. Which really was not the intent of the first spouse to die.
So really what we're looking at when we do the prenuptial agreements is to warn the people that now that you have it, remember that it's there. And before you do anything,
Consider the
consider
consequence.
how this would affect your estate plan and how it would affect your children. Otherwise, the prenuptial agreement might not have the value you think it does.
Absolutely.
Okay, and we're going to end on that note because we only have a few seconds remaining. So thank you for watching. Our show is Legal Lines. My name is Tom O'Shea. My guest today was attorney Leanne Miller from CGA Law Firm, and the topic was prenuptial agreements. Thank you.